Good morning, this is your Kelso Report for Tuesday, December 20th, and I'm your host, Clark Kelso. We begin with a labor law case in Plaza Auto Center versus NLRB. The Ninth Circuit held the National Labor Relations Board had improperly reversed an ALJ's determination that an employee's lengthy, profanity-laced outburst directed at the CEO of an auto dealership weighed in favor of the employee losing the protections of the NLRA. The employee was meeting with the CEO to discuss compensation issues when, in the course of that discussion, the employee entered upon an angry verbal assault on the CEO. In determining whether an employee who was engaged in protected labor activity loses that protection because of inappropriate employment behavior, the NLRB considers four factors known as the Atlantic Steel factors, which are as follows. First, the place of the discussion. Second, the subject matter of the discussion. Third, the nature of the employee's outburst. And fourth, whether the outburst was provoked by the employer's unfair labor practice. The ALJ and board agreed on the first, second, and third, and fourth factors, that those found in favor of the employee still having statutory protection against being fired. But the board reversed the ALJ's determination that the third factor weighed against protection under the Act. Well, the Ninth Circuit reversed that and held that the employee's outburst, which it described as obscene, degrading, and insubordinate, was enough to count against protection under the Act. The court remanded for the board to consider and reconsider its ultimate determination in light of the change on the third factor. Next, an immigration case in Romero, Mendoza versus Holder. The Ninth Circuit held that the petitioner was removable because he had committed a crime of violence and failed to establish entitlement to relief from removal. The petitioner asserted he had obtained derivative citizenship from his mother's naturalization in the United States. But the Board of Immigration Appeals concluded that his paternity had been legitimized under Salvadoran law, which defeated his claim to derivative citizenship. Now, the petitioner was born out of wedlock in El Salvador in 1979, but in 1983, El Salvador changed its constitution to remove any distinctions between children born in and out of wedlock, a change that was intended to legitimize all children previously born out of wedlock. Since the petitioner's father's name appeared on his birth certificate, the court held he was legitimized as an El Salvadoran long before his mother naturalized in the United States, which occurred in the late 1990s. Accordingly, there was no exception to his removability. Next, we have a death penalty case, California Supreme Court in People v. Eubanks. California Supreme Court unanimously affirmed another death penalty. The defendant in this case was convicted of shooting to death her four children, aged 14, 7, 6, and 4. And the court unanimously rejected the usual challenges in a 57-page opinion. Next, in the area of the law of evidence, in Casilla versus Department of Transportation, the 5th District affirmed a jury verdict in favor of the Department of Transportation in a wrongful death action brought against the department after a fatal cross-median accident on Highway 99 in 2003. The plaintiff claimed the stretch was unreasonably unsafe because of the absence of a center median barrier. The department made a motion in limine to exclude evidence of 4 accidents which occurred prior to 1994. In 1994, the department rebuilt the stretch of highway, changing it from 4 lanes of expressway with an 84-foot median to 6 lanes of expressway with a 60-foot median. The trial court granted the motion on the ground that the physical condition of the accident location had substantially changed, and the 5th District agreed with that evidentiary conclusion. The jury found the accident location was not in a dangerous condition at the time of the fatal accident and rendered a verdict in favor of the department. Next, juvenile law case. In In Re IA, the 1st District upheld the decision of the juvenile court, to place a baby at birth in the custody of the Alameda County Social Services Agency because the baby tested positive for cocaine. The mother abused drugs, which prevented her from caring properly for her baby, and both mother and father had engaged in domestic violence and had criminal histories. The father claimed the jurisdictional findings against him were not supported by substantial evidence, although the father did not challenge the juvenile court's other jurisdictional findings. The First District dismissed the appeal, since it concluded that even absent the jurisdictional findings with respect to the father, that would not change the jurisdictional finding with respect to the baby, and there was no effective relief other than placement with the agency. Next, another family law case, this time in adoption of Maya M., where the First District held that grandparents who had served as guardians for more than 2 years, pursuant to a stipulated guardianship order, agreed to by the parents, could adopt the child if that was in the best interests of the child, even without securing a finding that the parents were unfit to serve as parents. Section 1516.5 of the Probate Code specifically allows a guardian who has had physical custody for more than 2 years to adopt on a showing of best interests of the child. And the California Supreme Court has previously held in guardianship of Ann S., in a 2009 opinion, that the statute does not violate the due process rights of the parents because, by virtue of the lengthy guardianship, their interests have become more attenuated. Finally, in the area of remedies and default judgments, in Harbor Vista versus HSBC Mortgage Services, the Fourth District held, that the statute governing judgments in quiet title actions, which provides that, quote, the court shall not enter judgment by default, close quote, means exactly what it says. So the court reversed the trial court, which had actually entered a judgment by default, notwithstanding that statutory language, which appears in section 764.010 of the Code of Civil Procedure. Sometimes you just need to read the language and apply it as it is. A good case for the plain meaning rule. And that's it for today's Kelso Report. Have a great day in the law.